We're diving into a story that starts on a crowded train platform but ends up in the highest court of the land. And honestly, it's a case that'll probably change the way you think about your daily commute. You know that little token you buy or the card you tap? You probably think it's just a ticket, right? Well, in the eyes of the law, it's so much more. It's a binding promise, a contract that holds the train company to the highest possible standard of care. And we're about to see exactly what that means. So let's set the scene. It's October 14th, 1993. Picture a busy LRT station during the evening rush. A man named Nicanor Navidad buys his token. Just minutes later, he's in a fight with a security guard right there on the platform. Things escalate, and then the absolute worst happens. Navidad falls onto the tracks, directly into the path of an oncoming train. It was sudden, violent, and just tragic. Now, you might just call this a terrible accident, a fight that went horribly wrong. But legally, it's way more complicated than that. Navidad's death kicked off a years-long legal battle, and it all boiled down to one seemingly simple question: who's responsible? So let's first get on the same page and look at the facts of the case, the sequence of events that everyone involved actually agreed on. Okay, so everyone agrees on the basics. A fight happened, and it ended tragically. But here's the crucial part, the detail that changes everything. No one could ever prove how the fight started. Who was the aggressor? Who threw that first punch? This one, key unknown, would become the pivot point for the entire case. In the wake of this tragedy, Navidad's family wanted answers. They wanted accountability. So they filed a lawsuit, which pulled several different parties into a massive legal showdown. So on one side, you have the family, the plaintiffs, and they sued pretty much everyone they thought might be responsible: the security guard himself, the agency that hired him, the guy driving the train, and of course, the Light Rail Transit Authority, or LRTA, the people who run the whole system. The case first went to a trial court, but that decision was just the beginning of a really bizarre legal roller coaster, where the whole idea of justice seemed to get turned completely on its head. Okay, get this. This is where it gets confusing. The first court looks at the case and says the security guard and his agency are liable. The train authority, they're off the hook. But then, on appeal, the court does a complete 180. They clear the guard and his agency and instead find the train authority and its driver liable. I mean, how is that even possible? How can two different courts look at the exact same facts and reach completely opposite conclusions? Well, the answer isn't in the details of the fight itself, but in a fundamental legal relationship between you, the passenger, and the company you pay to get you somewhere. And that brings us to the most important legal idea here: the contract of carriage. The Supreme Court made it crystal clear that this contract doesn't start when you board the train. It begins the second you pay your fare. From that point on, Nicanor Navidad wasn't just some guy on the platform. He was a passenger, and the LRTA owed him a profound duty of safety. So with two lower courts in total disagreement, the case had only one place left to go, all the way to the top, to the Supreme Court. It was now their job to untangle this legal knot and give a final, definitive answer. So the court started by classifying the LRTA as a common carrier. Now, this isn't just a label. It's a special legal status that comes with a much, much heavier burden of responsibility than, say, you giving your friend a ride in your car. And that standard has a name: extraordinary diligence. This is the highest level of care the law recognizes. It's not just about being careful. It's about being as careful as a very cautious person can possibly be, trying to foresee any potential risks and stopping them before they happen. And here's the biggest legal twist of all. Once that contract of carriage exists and a passenger gets hurt, the law automatically presumes the carrier is at fault. The burden of proof completely flips. It was no longer the family's job to prove the LRTA was negligent. It was now the LRTA's job to prove they'd been extraordinarily diligent. So let's just walk through the court's logic. 1, the contract was in effect the moment he paid. 2, that duty of safety covered the entire station, including the platform where the fight happened. 3, this duty extends to the actions of its own employees and contractors, like that security guard. And 4, since the LRTA couldn't prove the fight was some freak, unforeseeable event, they failed to meet their burden. They couldn't overcome that presumption of negligence. So what about the guard? Well, this goes right back to that key unknown.
Since there was no proof of who started the fight or that the guard acted negligently, the Supreme Court agreed with the Court of Appeals. There just wasn't direct evidence to hold him or his agency liable for the fall.
And so the final verdict came down. The guard was cleared. The security agency was cleared. The train driver, who really had no way of stopping in time, was also cleared. The only party left holding the bag was the LRTA, not for the actions of the guard, but for its own failure to uphold that contract of carriage and ensure its passenger was safe. And that legal responsibility? It came with a price tag. The LRTA was ordered to pay the Nevada family over 164,000 pesos in damages, a concrete sum for breaking its contract for safety. Now, this case is from 1993, but it's not just some piece of legal history. Its principles define the promise that's made to you every single time you step into a bus, a jeepney, or a train station today.
The law itself is just so explicit and powerful. The duty is to transport you safely as far as human care and foresight can provide. Think about that. It's a demanding, almost absolute standard, and it exists for your protection.
So what should you take away from all this? First, your rights as a passenger don't start when the doors close. They start the moment you pay. Second, public transport companies have the highest legal duty to keep you safe on their premises, and that responsibility extends to the actions of their staff and even to protecting you from strangers. And finally, if something goes wrong, the law presumes it's their fault, and they have to prove otherwise. That is the power of the contract of carriage. It's such a simple, everyday act, isn't it? Paying for a ride. But behind that simple act is this profound legal promise of safety. It's a promise that was tragically broken for Nicanor Navidad, but it's one the law protects for all of us. So the next time you tap your card to ride, what does that promise of safety mean to you?